Good evening everybody and a warm welcome to all of you today on today's session. Before we begin our session, there are a few announcements to be made. So first is about a session happening on 13th of this month, that is on this Saturday, about labor law. It is actually labor law compliance and opportunities in practicing labor law. So it's quite different from regular sessions what we are holding it. It's about our own opportunities. So kindly do register for that. All the details are available on the website. And also please spread among your friend circle. There is one more session which is happening on April 20th, which is on real estate industry. It's a one-day seminar. It's called Vidhut Sabha, and it is happening at the conference hall at Legislature House, not at the branch office. That there has to be made. You have to make a note of that, and it's happening near Vidhan Sauda, not at the branch premises. So even for that, the registrations are open. So kindly do get registered. There are very eminent speakers coming on for that. And apart from that, you have a Kannada state level conference happening on June 7th and 8th, which is going to be in a big way. So please do register as soon as possible and also spread among your friend circle. And apart from that, there is one more initiative being taken now about career counseling, which is been already the details of which is there in the website. We are inviting applications and a kind of initiative from our CA fraternity, already qualified people, to go to the colleges and actually do a career counseling sessions. So we request all of you to please come forward and make this kind of initiative a grand success. Also spread among your friend circle who have already graduated from the colleges in Bangalore, Tumkur and Hosur, so that we can take this initiative further, and at least we are targeting for 100 colleges. So it's a good initiative to increase our CA fraternity people. So please do come forward and support all of us. And apart from that, today's speaker, I request Sriram Bhatt, the chairman, to accompany today's speaker, the CA Sunil Bumralkar, onto the stage and welcome with a floral bouquet. Please give a big round of applause for today's speaker. On to a brief introduction of today's speaker. CA Sunil Bumralkar has a bachelor's degree in commerce and is a chartered accountant. He is a fellow member of Institute and he is an audit partner with SR Batley Boy and Associates LLP, a firm chartered accountants and based on Bangalore. And he will be speaking with us on the topic called reporting on struck-down companies being revived from NCLT. And let it be an interactive session. And I think he has got a lot of inputs related to NCLT and also reporting and accounting practices related to that. So let's welcome to the speaker on the desk and let him take over the session. Thank you.
Good evening everybody, and before I commence the presentation, I want to thank Mr. Bhatt and the entire organizing committee of the Bangalore branch of SIRC for giving me this opportunity. I think the topic is, I think, very technical in the sense that so I think because considering the fact that even a little bit of dereliction in terms of complying with the rules and procedures which are enumerated in the Companies Act, essentially can create an issue with regard to companies being struck off from the register of companies, as well as when the companies actually file for the revival of these struck off companies, then ROC also could be held responsible for not complying with the procedures to the T, and which may entail in registering or reviving the companies which were earlier struck off. So the way, so I think though the topic is reporting on struck down companies revived by NCLT, typically what I wish to do is that give a perspective of what is happening, I think, with regard to the share companies and the companies which are being struck off. That's one. Second thing is that the provisions under the Companies Act, I mean 2013, as well as the provision which was applicable in 1956 Act. So essentially, more or less both of them are virtually the same, but there are certain subtle differences which I will explain to you. What are the rules and regulations, I think, which have been formulated, which essentially covers the procedural aspects of either striking off or reviving the company. What is the effect of restoration of the companies which are struck off? And then obviously there are certain case laws, predominantly there are case laws which are pertaining to the Companies Act 1956, but obviously there are certain case laws, I think, especially in last 3 to 4 years, which pertains to Companies Act 2013. So we will check some of the 4 or 5 the cases and see how the effect was given to companies which were struck off and then revived. I mean, what kind of orders the NCLT passed. What is dormant company? So I think there is another section called dormant company. And then typically what will be, say, reporting requirement, accounting standard implications, etc. And if then time permits, though I have not covered as a part of this presentation because it is not the current today's topic. What will be the accounting implication from, say, IBC perspective, I mean, insolvency proceedings perspective? That also I will try to cover certain aspects in brief. So if you look at it, I think, there has been such a spate of news, especially in last 2 years. I mean, if you look at, say, in 2017-18, I think, the government became really strict in terms of, I think, monitoring these shell companies, and to a certain extent, I think, if you recall, I think, the demonetization was essentially a kind of a trigger for some of these activities, and I think it was followed up by ROC and the MCA actually pursuing vigorously, the companies which were essentially not operating, or companies which were shell companies, not operating for few years, companies which are not complied with, some of the critical company law requirements, say for example, filing of annual return, filing of financial statements of the companies. Many times the companies were not traceable, the registered office on which they were registered, those were different, directors were not traceable, etc., etc. And so I think there was a huge impetus which was taken. And what was then observed was, and this of course is based on a whole lot of information, I think, which is on the web, is that typically as of January there are about 17.5 lakh companies which are registered with the ROC. And out of that only 66 to 67% only were found to be effective. So you are literally talking about almost like 6 lakh companies which were essentially not operating. And I think something which is also on the record, and as you, if you go through the web or if you go through some of the old, the news items, in 17-18, almost 2.25 lakh companies were struck off, by ROC suo motu. So this is on its own in 17-18, and what we also understand is that there are additional 2,25,000 companies which are being pursued for striking off in 18-19. So that's a significant number. So you are talking about essentially 4.5 lakh companies which will be struck off over a period of 2 years. And while there are a number of companies, I think, which could be shell companies, etc., but majority of these companies which I think ROC is pursuing in terms of striking off, either in the earlier year they did that, and this year they continue to pursue that, will be essentially on account of two critical items, which is not filing financial statements for last 2 years and not filing the annual returns for the last 2 years. So I think, so this is what I think is the, the effect. So you are literally talking about 30 to 35% companies which will be essentially taken out of the, the registers. Now this entire thing was, drive was essentially towards shell companies, stricter provision, compliance of the provisions of the Companies Act. And of course, I think if you see the Companies Act penal provisions, I think the penal provisions have been significantly enhanced, and disqualification of directors. I mean, as auditor, for example, we are supposed to report on the 164(2) with regard to the disqualification of directors, which essentially one of the key conditions is whether the companies in which the directors are involved, whether they have filed the accounts and the annual returns for 3 consecutive years or not. And if it is not done, then the directors are automatically disqualified and they vacate the office. So it's a very kind of a welcome, steps, in making sure that that the companies comply with the Companies Act requirements. Now, so what happened is, and if you recall the way the Companies Act was, it was formulated in 2013, but the implementation was in stages. So there were certain sections which were, notified at one particular point of time in 2014, and so on and so forth. And if you see 2016, the notification for section 248 to 252, which essentially governs the provisions for striking of the companies as well as reviving the companies, were notified on 26 December 2016, and of course I think the relevant rules, okay, for striking of the companies from the register of companies were also formulated, which actually laid down the procedures based on which the procedure for striking of the company's name has to be followed. Now, with regard to the revival of the companies, those are essentially coming through companies' miscellaneous rules and companies' NCLT rules. So, revival of the companies is essentially coming through the NCLT rules, because the power of revival of company has been granted to NCLT, which used to be earlier with the court when the old act was there, that is the 1956 Act. Now, one of the key, and when I discussed about that, it is more or less similar to the old Companies Act, which is under, so that provision was covered under section 560 of Companies Act 1956. But the major difference between the two is that the only registrar had suo motu powers to do strike off under the old Companies Act, but under the new Companies Act, even the company on its own, based on the shareholders' resolution, can actually file for striking of the name of the company from the register based on certain criteria, which we will look at it separately. Now, this is the section 248(1) is where ROC does it on its own. Okay, so what are the situations in which I think the ROC can actually strike off the name from the register of members is if within 1 year the company has, from the date of incorporation, the company has not commenced the business, or they have not filed, the company is not carrying on any business or operation for a period of immediately preceding 2 years. There is another condition which is there, which of course I have not noted, is that if the subscribers to the memorandum have not paid the subscription within 180 days, then that is the third condition, I think, which has to be satisfied. And the registrar, based on, and has not made an application for being a dormant company. So what happens is that and which I think this particular section we will cover it separately, that if a company actually applies, okay, if the company has not started its business within 1 year or has not commenced its operations in 2 years, in 2 years from the date of incorporation, then company actually can on its own apply to registrar, or even registrar of companies based on the information which is available with them, can actually move the company from an active company to a dormant company. So if the company is moved from active company to a dormant company, then the provisions of strike-off are not applicable to that particular company for at least 5 years. But if that company remains dormant for 5 years, then obviously the procedure for strike-off will become applicable. So this is essentially moving company from active to dormant is essentially giving a relief to company from the stringent provisions of the strike-off of the company. Now, what are the procedures that which the ROC has to follow? So the ROC has to send the notice to all the directors of the company, which contains the reason why it is removed, and along with the copies of relevant documents, and within a period of 30 days, the company and the directors have to essentially respond, okay, to the ROC as to why the company should continue to be live or active on the register of companies, and that has to be submitted within 30 days. And if the ROC is not satisfied with the representation made by the company, then obviously I think he will go on to remove the name of the company from the register of companies. But what is also important to know is that the regulatory. So I think the critical aspect is not just getting information from the companies, but the registrar of companies has to also give notice to the regulatory authorities, say for example income tax authorities, or in the old days we had excise authorities and the service tax authorities. So the registrar of companies also had to serve that notice to them to seek any objections which they had. So that is the kind of a procedure which is required to be followed, and the notice for removal has to be given in a particular form. It has to be obviously placed on the website of the MCA, published in the official gazette, and the notice had to be given in one English newspaper and one the regional language newspaper, which is having a kind of a sale in the state in which the registered office of the company is situated. Now, intimation also about the proposed action and all has to be done, and seek objection, and then ROC may, after the expiry, unless the cause is shown to the contrary, will give a notice to the effect saying that the company has been struck off from the register, and then once the company is struck off, then the company becomes dissolved. Okay. So typically now, what is the effect of all these provisions? That when the company is dissolved, is typically then company cannot function as a company because it is no longer registered on the register of the companies. However, before striking of the, typically if it doesn't function, then what happens to its liabilities, what happens to its bank accounts, how the liabilities will be settled, what happens to the interest of the creditors, what happens to the interest of the members. So in that particular situation, before ROC actually takes a decision to strike it off, okay, he has to satisfy that whether the sufficient provision is made to settle all the liabilities of the company. This is the most important provision which is there. So till ROC is satisfied that the company has made all the arrangements in complying with, in fulfilling all its liabilities, financial liabilities, statutory liabilities, etc. I don't think ROC will have a power to strike off these companies or issue an order to dissolve these companies. Now, of course, there are certain. Now, the other aspect I think which is very important is that these liabilities which are there, which I think ROC needs to satisfy whether they have been settled or there is a sufficient provision made to settle the amount. This liability has to be only those liabilities which prevail till the dissolution of the company or just before the dissolution. So obviously, you cannot entertain any other liability which arises or emanates after the dissolution of the company. This is one critical aspect of it. The other aspect is that under the new act, the old certificate of incorporation stands cancelled, and then as soon as the company is dissolved, and if the company is revived, and I think when we will talk about those provisions later, is that the ROC has to issue a fresh certificate of incorporation. Now, dissolution of the old certificate of incorporation and issuance of a new certificate of incorporation, what are the implications? I think we will discuss it separately when we discuss the case laws. However, I think there are certain companies, I think, which are excluded from the applicability of this particular provision. So typically, for example, listed companies cannot be struck off, okay, by ROC. That's one. Companies that have been delisted due to non-compliance with the stock exchange regulations or ROC regulations. So for example, companies have not complied with the listing requirements, and for example, SEBI has actually taken a decision to delist those companies. Then such delisted companies cannot be struck off from the register or dissolved for obvious reason, because there are certain penal consequences which arise out of non-compliance with those, and unless those are fulfilled and the regulators are completely satisfied that there is nothing which is fraudulent emanating out of it, you will not be able to dissolve the company, because once the company is dissolved, then all the actions, I think, typically get terminated at that particular point of time. Vanishing companies, I think, there is this one terminology which is used in the Rule 3 of the company's removal of names. So what is vanishing company? So vanishing company is one which is listed on stock exchange but have failed to file a return with ROC and stock exchange for consecutive period of 2 years, which is essentially where the companies essentially get struck off from the register of companies. Not maintaining so typically the same thing that you give the registered office to ROC as well as to SEBI, but the company doesn't exist on that particular address, and the directors are not traceable. So these are called vanishing company. Again, why these are excluded from the provisions of this section is obviously because then there could be a fraudulent intent here, and then the companies will have to be pursued vigorously to put those to the logical conclusions. Companies where the inspection is ordered and the inspection is still pending or the order is not passed. Companies where the notices of inspection have been issued, a report is pending, ROC has, for example, ordered the inspection of the accounts and so on and so forth. But the effect, the conclusions have not been drawn. In that case, obviously, these kind of companies cannot be removed, from the register of company. If there is any prosecution, compounding of office, the company has filed application for compounding of office, but no decision has been taken on that. Companies which have accepted deposits from public and they have defaulted on complying with the provisions of the Companies Act, again there are certain penal consequences, and to that extent I think, if the company is dissolved, then you will not be able to pursue those penal consequences. Companies having charges which are pending satisfaction, for example banks, so this is essentially to protect the banks that, the charges are there, assets have been charged for the borrowings, but it is still pending satisfaction. Then obviously that means that the loans have not been repaid or maybe they are overdue. And in that situation, you will not, order a strike-off. And then company which is not for profit, either registered under Section 25 of the old Act as well as Section 8 of the new Act. These kind of companies are outside the purview of this particular section. Now, what are the grounds for? Now, this is a provision which was not there, Section 248(2), which is a strike-off by way of filing application by the company, which was not there under the old section, which is Section 560. But now the companies have been granted, permission to file for strike-off on their own. Okay, provided certain conditions are satisfied. So one is that if the company has extinguished all liabilities, then only it can file this particular application. So that is one part of it. The second part of it is that either you have to pass the special resolution of the shareholders, which typically means 3/4 of majority, or 75% of shareholders have actually you have taken a consent of. So even if you are not to hold the meeting, you have taken a consent of the shareholders. Then you can file the application to the registrar for removal of the name. And registrar, again, after receiving this particular notice, will cause a public notice to be issued in the prescribed manner, and which is what is prescribed manner is, it is mentioned in those rules which we talked about earlier, rules for removal of company's name from the register of companies. And then obviously I think, if a company which is registered under any special act, for example, insurance company, etc., obviously the ROC cannot take those decisions, to remove unless, you have taken the permission of those statutory or regulatory authorities. For example, if it is an asset management company, then the ROC will have to also take a view of SEBI before, taking any action on this particular application. And the grounds of application will be the same as what was there in 248(1), which is essentially, I'll just go back, is these three. Company failed to commence the business, and company has not been carrying on any business or operation for a period of 2 immediately preceding. So even the company on its own, so sometimes this happens that you have formed a company, but I think the purpose for which you have formed a company, I think because of various conditions, maybe market conditions or just the priorities have shifted, the company may decide not to pursue this. Now, in those kind of situations, the company has been given a kind of a right to apply to ROC for a suo motu removal of the company from the register of members. So these are the procedures that the company has to follow. Hold a board meeting, hold a shareholders meeting for getting an approval for removal. And as I said, statutory authority, if you are under a special, if you are a special category company, then you will have to take those approvals. And then you have to file the form in STK2, form STK2, which is again prescribed, and there is a format also which is given in those rules. There has to be an indemnity bond which will have to be given by the company, because obviously there will be a lot of liabilities and the statutory liabilities which will be there. There could be cases which are pending, so how do we settle those cases? So I'm sure, I think there will be an indemnity bond which will be given to cover some of those contingent aspects of it. An affidavit by every director of the company will be filed. And a statement of account containing assets and liabilities of the company just before the, 30 days before the such a decision to be taken will be submitted to ROC. And pending litigations, which I think ROC will obviously look at it in terms of before taking a decision as to whether this particular application should be allowed to proceed further or not. Then ROC again will follow essentially what are some of the provisions which are applicable to suo motu, where ROC on its own will have to do it. Similar procedure will have to be followed in a different format, that there will be a public notice given for inviting objection from from any public for this strike off, and within 30 days I think all the notices or any objection will have to be received by ROC. Then it will be published in Gazette. There will be a newspaper intimation. ROC will simultaneously inform all the regulatory authorities, like say Income Tax Authority, Central Excise Service Tax. Of course, this language is from the Act, which is the old Act. So now obviously you will have the GST and the other related requirements there. And after following all these particular aspects, if ROC is satisfied that the company can be struck off from the register of members, then he will take the decision, and then the dissolution of the company will be published in STK7, form STK7, and then once the publication is done, then the company will stand dissolved from the date of publication in the official gazette. What are the other key provisions for in section 248? The other provisions are that that the registrar shall satisfy that sufficient provision has been made for realization of all amounts due and the payment and discharge of liabilities and obligations by the company within retirement, and taking undertakings from the managing director or other persons. So what happens is that now the most critical aspect is covered in the last para of the slide, is that see, once the company is dissolved, it ceases to exist. So it ceases to exist as a legal entity. But just to protect the interest of the creditors and statutory authorities, what is also provided is that whatever happens, whether the company is dissolved or not, you have taken indemnity bond, you have taken undertakings from the directors, etc. The company shall make available all the assets of the company for discharge of liabilities and payment of liabilities and obligation, even after the order for removal of the company's name or company is dissolved and it is struck off from it. So this is a very important provision which essentially protects the creditors as well as the statutory authorities with regard to the dues which are kind of due to them from this company. It could be loans to the company, and obviously I think before the registrar passes the dissolution order, anyway he or she has to satisfy that all these aspects are taken care of. But still, okay, even after taking all these precautions, if something were to go miss, then this particular provision continues to be applicable. But what is important is what I mentioned in the earlier slide is that all these liabilities which are crystallized or which were pending litigation at the time of dissolution or just before the dissolution only will be entertained for the purpose of settlement. Any liability, suppose if for some reason were to arise after that, then obviously I think this will not be covered. Again, I think the fact that I think this is a very onerous and responsible activity because the company will kind of essentially cease to exist. The liabilities of the directors and the key management members of the company will continue to remain, okay, and they will be even personally liable to the extent anything remains to be settled which is legitimately due from the company. And as I said, that liability has to exist on or before the date of dissolution. And then obviously, I think the other aspect is that striking of the company, dissolution of the company is not the same as winding up. Okay, so there is one case law which says that striking of the name of the company is actually an administrative act by the ROC, and winding up is actually where the company is literally erased from the completely. I mean, where all its assets are settled or its liabilities are settled, and it just continues to not. I mean, after that it doesn't continue to exist. So there is the subtle distinction between winding up is that winding up actually puts an end completely. But with regard to strike off of the name from the register of members, it is actually an administrative act, and because it is an administrative act, there is also a provision for the revival of the companies, I think, which we will look at separately. But there can't be a revival of a company after it is wound up, that's for sure. Now, so I think there is one provision which says that who can the company make this application, and in what circumstances it cannot make this application for striking of the name on its own under section 248(2). So what it states is that if a name has been changed in last 3 months or the registered office of the company is shifted in last 3 months, the company has actually made an effort to carry out a business, trade and business, in the previous 3 months, then obviously the intent is actually to continue to carry on the business. So, or the company has just disposed of the liability, assets or property in last 3 months. And the reason why this particular aspect is covered is that, say for example, if I have a liability for which there could be an asset cover, but maybe with some fraudulent intention the company want to sell that property so that they can take the money away and the liabilities are just left unextinguished. Just to cover this particular aspect, they have said that if in last 3 months if the company has done any of these activities, then the company cannot file application for striking of its own name from the register of company. Same, I think, provision worded a little differently. And the company has actually made a application to NCLT for doing a compromise arrangement, typically under the Companies Act. Now in those kind of circumstances, obviously it cannot make an application for striking of the name because these two are there, because there is one ongoing settlement which is going on, and pending that settlement, I think this particular action cannot be taken. And then obviously the company is being wound up voluntarily or by the tribunal. In that case, then this striking of and company filing an application for doing a strike off just doesn't arise. So what are the effects of the companies being struck off is that it ceases to operate, then certificate of incorporation issued is cancelled. Okay, but as I said that the realization of amounts of its assets for settlement of liabilities which were due before strike off or dissolution will continue to remain. Liability of every director, officer of the company and exercising power of management will continue, so those personal liabilities will continue. Now there are two aspects. One is that if you look at, say, disqualification of directors, now 164(2) says that one of the conditions of disqualification of directors is that if the accounts or annual return is not filed for consecutively 3 years. But here the strike off of the name from the register of members is if that particular active happens for 2 years. So what happens is that what does that mean? That once the company is struck off, what happens to the directors? Are they disqualified or they continue to be there because that only 2 years provision is fulfilled vis-a-vis 3 years? And then whether they continue to remain the directors, whether if they are disqualified, then do I need to appoint a fresh set of directors in place of those because they have already vacated? I think some of these issues, not all of these issues have been settled, but some of these issues have been discussed in the case law, so which I think I will cover in the subsequent slide. And then of course there is a proceedings of defunct companies are stated. Means if a defunct company is actually taken some action or a legal action against another company, once you strike it off, then that particular thing is stayed because that company no longer continues to exist. So obviously you can start that action provided you apply for the revival of the company. And then bank accounts and all are frozen, they cease to exist. Then there are certain penal consequences. I don't want to get too much into details. I mean, after there is some error here in 248(1), it's actually 249(1). So, I mean, if any intent, if it is done with an intent to defraud, then either 447, it's not 247 but 447, or penalty of 1 lakh will be levied if the whole intention of applying for a removal of the name from the register of companies by the company is with an intent to deceive or defraud people. Now what are the provisions for restoration? So what happens is that because as I said that this entire act or this entire provision is an administrative effect. What typically it means is that any person aggrieved by the order of the ROC, so can actually file an application to NCLT within 3 years for revival of the company. Any person, and this any person actually means company, employees, its workmen, its members, its creditors, or anybody who is aggrieved by that. So it is not restricted to only the stakeholders who are part of the company, but even somebody who is completely aggrieved by this particular action can actually file an application with tribunal for revival of this company. It can be actually filed by another company. Suppose somebody is a creditor. I mean or some case is going on, something is pending. Even that company can file saying that I think this order is unjust and this company needs to be revived, only to take care of some of those aspects, not necessarily just to run the business, but we will settle some of these obligations, and it is perfectly fine. I mean obviously it will all depend on whether ultimately NCLT decides that that is a just cause to do it, but I think it's all possible. And then I think the tribunal will pass the order if it is justified that it is not, it was unjust to remove the name. And then obligation filed by ROC. ROC can also file within 3 years. Okay, and application if they feel, I mean if ROC feels that actually the removal has happened through inadvertence, okay, they can actually file or incorrect information was furnished by them, so then they can actually go back and file for a restoration of the name of the company. Then tribunal, and then the third aspect is that on application filed by company, member, creditor or workman, okay, within 20 years actually you can, 20 years from the date of dissolution order, okay, any of these entities can actually file for the revival of the company on the register of members. So in the first two cases it is 3 years. So the first is the application by any person, which includes the third, some of the people and the constituents who are in this particular provision are actually a subset of the first one. So there is a 3-year limit. For ROC on its own it is a 3-year limit, but application filed by company or any member or creditor or workman, you can actually file it 20 years before, I mean within 20 years from the publication of the Gazette. And this is only, NCLT obviously will pass the order only if it was satisfied the company was actually carrying on the business or operation, or otherwise it is just that, I mean it is just in the sense that it is in the fairness of things that the name of the company has to be restored to the register of companies. And NCLT has got all the powers to give direction to the company in what fashion or in what manner this needs to be done, including settlement of liabilities, differing of cost, penalties, filing of pending, documents, statutory returns, etc., etc. But in all the judgments, at least which I have seen, so far, is that they have restored it retrospectively. So that means it is not prospective. So they have restored it as if this company was never struck off from the register of members, register of companies. And what are the rules? I mean, so there is a rule 87A under the National Company Law Tribunal Amendment Rules, which essentially prescribes the whole provisions vis-a-vis, what kind of forms, what is the procedure which is required to be followed. And these are obviously the NCLT rules. And then obviously once the application is filed, then the copy of appeal or application also will be given to registrar. Then there will be a hearing, typically as like a court. And then the tribunal, once it passes the order, then they will issue the order, then it has to be filed with ROC. Then ROC, the appellant can do pay to the ROC his cost and acknowledged by the appeal. So here all these directions will be given by NCLT depending on the gravity of the situation. And most important is that all the pending requirements of the Companies Act, including fulfillment of filing statutory returns, annual returns, financial statements of the companies for whatever period which has not been done. I think this will be one of the most important prerequisites which NCLT will look at before filing the order. So I mean, if I look at say many of the case laws, I have not seen a situation where NCLT has said, okay, it is prospective, so you don't have to worry about what happened in the past. I don't think there are any such case laws, and I think that is not the intent of the Act also. And then of course NCLT can either restore the name or they can reject the name. And in number of cases is done such as, so I think typically the companies, I mean, if you look at the case law, the companies actually filed these applications. Say for example, the company was not doing well, was kind of dormant, defunct, because, the existing management thought that there was no particular reason to continue this particular company, but there could be a change of management, for example, which can consider that there is a perfectly good market conditions prevailing for this company to survive and continue its operation. So there are a whole lot of things I think which go into for revival of these companies. And obviously the object of the Companies Act is to put the company and their parties in exactly the same position or as near thereto as possible as they occupied, as if the dissolution had not taken place. And rights of parties would be as if there is no cessation of the activity. And this is completely different, as I said, that this is distinct from winding up by the liquidator, where company just ceases to exist, versus the removal of the name by administrative act of ROC, which is not absolute or irrevocable. So I think some of these case laws, I mean, we will not get into the details, but I think if you see that, I think the registrar of companies struck out due to default in statutory compliances. Petitioners actually made an application saying that maybe we filed it, but it was inadvertent, or somebody we tasked them to file on our behalf. They didn't do their duties. Management was not aware, and I think based on whatever submissions which were made, I think what NCLT actually took a view here, or this is under the old Act, so it is under the Company Law Board or the court, is that they actually took a view that even though maybe somebody else was interested in the task, but ultimately it was the responsibility of the management, so management did not fulfill its own responsibility, but we are fine in reviving this company, so we are okay with that. Okay, but then we hold you responsible for not complying with the rules and regulations, and for that there are penal consequences, there will be compounding of offences. File all those statutory returns within certain period, pay all those penalties, etc., etc. And once that was evidenced, then they allowed the company to continue. Same thing is here, that I think they admitted that there was a clerical negligence, but the law court actually took a view that it is ultimately the management's responsibility, but the company was allowed to be restated after settling all the liabilities, statutory liabilities, filing statutory returns, etc., etc. And obviously it has to be done. There was a judgment where they stated that under 560, which is a similar section, is that there was a judgment which said that NCLT actually refused the order, and the reason for refusal of the order was they considered that there was just no case for the restoration of this particular company. In another case, like this Serious Transtech, which is under the new act, which is section 252, NCLT ordered the restoration, to act. They even allowed the DIN numbers to be reactivated. So, I think few slides back I discussed about disqualification of directors being on a different footing than the striking off of the company. But here NCLT actually went ahead and told the company to restore the DIN number of these directors. So directors actually continued to be as if they were always on board as a director, which is not essentially the provision of section 164, which says that once the directors are disqualified, they actually vacate and you need to appoint new directors in place. And similar kind of judgment was given in these other two cases which are under the new act. Now we talked about this dormant company situation. So in case of a dormant company, what typically happens is that what is a dormant company? I mean, so first, before the company is actually moved to dormant company status, either on the application of the company or by ROC on its own, it has to fulfill the definition of dormant company, which is that it was formed for a future project. So I think I essentially talked about that formed for a future project, but that project is not taking off. But till that happens, then what do we do? Okay, and there has been no significant accounting transactions. The company was formed, there was a project which was supposed to have taken off, has not taken off. We have paid only the statutory related dues or application fees, etc., etc. So there was no significant accounting transaction, and they have actually defined what is a significant accounting transaction and what is an inactive company. And if these conditions are fulfilled, then you can actually move the company from the defunct company to a dormant company. So rather, or to say that once you move it to defunct company, then it cannot be struck off, unless the provisions which are related to striking of the company are fulfilled. So dormant company actually gives a relief for the company not to get struck off, in the intervening period. And the company can remain a dormant company for 5 years. But after 5 years, then if no action is taken by the management of the company in reviving the company, then the ROC can take a decision to strike off this. Annual returns and all. Yeah, so what happens is that the dormant company otherwise has to fulfill all the requirements of the company, right? So it has to have the same number of board of directors, it has to file audited accounts. Rotation rules of auditors are not applicable to that company. You have to comply with the accounting standard, but if you go to accounting standard rules, okay, it states that accounting standard 3 pertaining to cash flow statement is not applicable to dormant company. There is a specific provision for that. However, all other sections all other accounting standards are applicable. As you are aware of, that Ind AS has a different applicability. It is talking about 250 crores net worth and beyond 250 crores net worth. So they have a different applicability here. But with regard to the old accounting standard, that is Indian GAAP, the pre-Ind AS GAAP, I think AS3 is not applicable to this particular company, but all other provisions are required to be fulfilled. And what is the inactive company? Inactive company is essentially the same definition, more or less, what was there in 248(1), that company which has not carried on the business for last 2 years, etc. And has not entered into any significant accounting transaction. And the significant accounting transaction means any transaction other than payment of fees by the company to ROC, or to fulfill any requirement of law, allotment of shares, and payment for only maintenance of office and records. So in a nutshell, what it means is that for the company to continue as a dormant legal entity, whatever expenditure I need to incur, if I incur that, but no other significant accounting transactions in the company can continue to remain a dormant. And then obviously I think dormant companies, status can be obtained by the company only if no inspection or investigation is ordered against this particular company, nor any loan or any significant statutory dues or cases are pending against this company. You can't shift a company to a dormant company if otherwise it has got any loan or borrowings outstanding. Now, what are the reporting requirements? Now, I'll tell you that before I get into this particular thing, I think we looked at 2-3 critical aspects. One is movement of a company which is otherwise not carrying on any significant business activity, okay, for 5 years to a dormant company status. Okay, so dormant company, just now we looked at the definition that it has no significant accounting transaction other than expenditure incurred to fulfill the requirements of maintenance of that office and all the payments of statutory dues which are required to keep the company live. So this is one status which will remain for 5 years. And then the second aspect is that the company which otherwise is going to be revived after being struck off, and typically I think that particular period which is given is 3 years in one particular case. When the company or the workman or the creditor can actually apply within 20 years to revive this particular company. So obviously I think there are so many questions which arise in our mind is that what happens to intervening periods. What happens to the company, which is struck off, then it is in a kind of a situation that it is no longer in existence or administrative existence as it is. I think we should call it that way. Then NCLT passes the order, then NCLT actually says that you will revive this company from maybe the retrospective effect, and I think that is the intent of the company, so it will be revived with the retrospective effect. Then the other aspect is of course the fact that assets and liabilities, assets will be available for disposal of all the liabilities even after dissolution pertaining to the liabilities which are there before the dissolution. Okay. So there are a whole lot of implications, and most important is when the accounts are, when the company is struck off, the bank balances and the bank accounts are frozen. So what happens to the company? So I think some of the things, of course, we will discuss it a little bit in detail, is that in case of a dormant company, you have to actually file a statement of accounts, okay, duly audited by a chartered accountant. So there has to be a return filed, okay, which is essentially a statement of accounts and a position, okay, which has to be filed by April, and then obviously if you do not wish to not comply with the company or act requirement, then obviously audited statement of accounts of these companies will have to be filed along with the annual return. Otherwise, if it doesn't happen over 2 years, then then there is a danger that this company could get struck off. You are not fulfilling the regulatory requirement. Moving the company from a strike-off situation to a different situation doesn't mean that I get exemption from compliance with the laws and regulations. So that I think is the most important aspect of it. The second aspect is that in case of a company which is being struck off, okay, now what are the 2-3 things I think which will definitely come in is that because the bank accounts are frozen, okay, and let's look at the scenario that bank accounts are frozen, company is not able to do any business, and they go and approach NCLT that we wish to revive this company. NCLT actually gives an order, okay, to revive the company on the condition that you will file all the pending financial statements of the company, okay, and you will also and then obviously you will regularize it over the period of time. And so to my mind, I think what a company will have to do is that it will have to prepare full-fledged financial statements of the company for last 2 years. I mean, depending on, take an example that, okay, they have not filed it for last 2 years, so then we need to file the financial statements for last 2 years and we need to continue that. But because the company was struck off from the register of members, there could be certain situations which could have a serious implication on the financial well-being of the company. Okay, so there will be a whole lot of aspects, I think, which we will have to essentially cover, which is typically, I think, the most important aspect will be that after the strike-off, in the intervening period till the company is revived, okay, when my bank accounts and everything is frozen, okay, I mean, what happens to the status of the company as a going concern? I think so. To my mind, I think the most important thing, which as an auditor, okay, whoever is auditing the financial statements of the companies which have already been struck off or for the pending period, as well as for the period going forward, I think one of the critical conditions will be that what is the implication of this strike-off had on the well-being of the company and what are the implications of this particular aspect in the intervening 2-year period when the company was not operating, and after revival, how it will continue to remain as a going concern. And I think, there, to my mind, I think we will have to fulfill the requirements of standard on auditing 570, which essentially gives 3 options. One is that when the going concern is inappropriate, okay, that even after revival or in the intervening 2 years period, okay, the condition is such that this company cannot continue to function as a going concern, there will be obviously a adverse opinion. Second thing is that you may assess, or management first will have to assess the situation, and then the auditors of the company will have to come to a conclusion that yes, the going concern, there is a material uncertainty on the company's continuance of a going concern. However, there are certain steps which are being taken by the company, okay, and there is evidence to that effect that maybe the company is looking at reviving the business, raising finance, approaching the banks. They have raised, maybe they are ready to raise equity. They have the necessary wherewithal to approach investors to get the funds. Okay. Auditors will have to literally look at all those aspects. Okay, what are the future plans? What are the future cash flows of the company? How company intends to revive this particular company? And then if the company and if the auditor is satisfied that this particular situation could essentially move the company towards carrying on a business on a going concern basis. If you look at, say, standard on auditing, our reporting standard, where a specific para on material uncertainty of a going concern is required in the audit report, which I think the auditor will have to give. Okay, management will have to give a detailed note in the notes to accounts. Okay, explaining the reason as to why a particular situation or a financial stress has happened vis-a-vis, I think, what are the plans which the company enters into, wishes to enter into to revive this particular company. And if these disclosures are adequate, okay, if my auditor considers so then the only requirement will be to give this uncertainty around going concern, material uncertainty around going concern as a matter of emphasis and not as a qualification, provided the disclosures in the financial statements are adequate and satisfying. But third aspect is that there is a material uncertainty. The company is taking steps, but if auditor believes that the disclosure which is made in the financial statements of the company is not adequate, then again the same situation will prevail, that the auditor will have to either give a qualified or an adverse opinion. So I think these are the situations typically will come in. So this is on the assumption that in the intervening 2 years or 3 years or whatever, I mean, you have literally got 20 years to revive the company. What is the effect this closure or the strike-off had on the company, because it couldn't fulfill or it couldn't continue the business in a normal circumstances? On the financial position of the company, the well-being of the company will have to be assessed by the auditor. So that's the critical aspect of it. Other aspect is that NCLT obviously will pass the order vis-a-vis restoration of the company from retrospective effect after fulfilling the pending statutory requirements, including filing past audited accounts, etc., etc. But when the company was struck off, so there was no auditor who was in existence because the company itself is not there. So then obviously the company will have to look at the auditor, or appoint an auditor, or maybe the old auditor, if he has otherwise not required to be rotated out, can continue to be the auditor once again and then take that forward. Essentially in these circumstances, I think the old auditor who typically was there before the company was struck off and we need to file say last 2 to 3 years of the financial statement, then it is important that somebody who is already familiar with the company's affairs comes on board, subject to the requirements of course the rotation of the auditor's rules. I think that could be one strategy which the company can adopt. We talk about directors' disqualification. So when the company is struck off and the directors are not there, so to fulfill the requirements within the intervening period, okay, because what happens is that the company is struck off, we have filed the application with the NCLT and the order will come later. Now in the intervening period, when I am filing the application with NCLT, I am not going to wait for the NCLT to pass order before I start fulfilling the conditions which are required to be fulfilled in terms of non-compliances. You will start actually complying with it, doing the audits. So there could be an appointment of directors will have to happen as soon as the company is revived. If the NCLT order continues to give effect to the old directors, then the old directors can continue. But if the company NCLT order doesn't talk about that, then in the intervening period, the company will have to appoint new directors who will take the responsibility for the governance as well as the statutory responsibilities which are required to be fulfilled by the directors, and then take it forward. So this is the second angle, I think, which will need to be covered. And please note that while under section 560 there is a certain precedence, but under section 250, 248 to 252, I think this is a new provision. So as the case laws you get more and more case laws, I think some of these positions will become clear, and especially because a large chunk of companies have been struck off in last 2 years. So what those implications will be for going forward in terms of how many of those companies will ultimately be revived. We'll have to, I think, wait and see as to how this happens. This is one aspect of it. The other key aspect will be that disqualification of directors. I think auditors will have to assess the reporting requirement. I mean, as auditor, we need to comment on whether the directors under section 164(2), whether they were disqualified or not. Obviously, in this particular situation, because of the non-fulfillment of statutory obligations, 3 years versus 2 years, if that is happening, then we'll have to kind of look at it from a qualificatory perspective. I think if the company is sufficiently well capitalized or has assets and liabilities at its disposal, or intangible assets are there, I think the most important aspect will be that for an auditor to actually look at the provisions pertaining to impairment of assets, which is under Ind AS 36, or if company is not fulfilling Ind AS 36 Ind AS requirement, then under AS 28 of the old accounting standards. I think as an auditor, there will be an imperative and a responsibility to look at some of the critical aspects here. Many a times, I think you will encounter a situation that in these particular situations, there could be certain carry forward losses, etc. And what the impact will be on creation of either a deferred tax asset, whether the company has created a deferred tax asset, if it has created deferred tax asset, whether you can actually continue to hold that as an asset or not, I think will be another most critical thing which as an auditor that we will have to fulfill that responsibility. And here again, a company which is complying with the old accounting standard, which is accounting standard 22, we had a virtual certainty criteria which was required to be fulfilled versus the reasonable certainty criteria which is required to be fulfilled under Ind AS. So it was far more stricter than today under Ind AS. So that is one aspect I think which is very critical. Provision for impairment in value of investments, if any, on the similar lines as impairment of assets will have to be looked into. If there are any receivables, if there are any loans and advances, deposits given, etc. Whether there is an expected credit loss required, provision is required under the 109, or provision for doubtful recovery is required under the old accounting standard. I think we will have to look at it. Lastly, I think with regard to discontinued operations, now it depends on what kind of situations will be prevalent at that particular point of time. I think we will have to also take into consideration the requirements of these non-current assets held for sale, or under Ind AS 105, or under old accounting standard 24, which will have to be looked into for some of these compliances. So I think and all these aspects, I think we will have to take into consideration only because the company was struck off, it didn't exist administratively, bank accounts frozen, couldn't carry on the business, etc., etc., and what those implications will be from financial statements perspective, our reporting requirements perspective, what will be our implications with regard to disqualification of directors, what will be the requirement with regard to compounding of offence, making provision for those or paying those, booking those in the accounts, etc., etc. I think these will be some of the really critical challenges which will be there, and as the as the strike of was more remote or more in the past, I think the challenges in terms of complying with the pending regulatory requirements, including pending financial statements, will be absolutely challenging and critical. So I think with this, as far as I think this topic is concerned on 248 to 252, I think this is what I have to say. But in fact, I think Mr. Bhatt was telling me that whether I have anything to say about any incremental reporting requirements vis-a-vis IBC. I mean, because we have these insolvency proceedings which are going on. Now, obviously, I will not get into the technicalities of how it needs to be done, etc. I will only look at some of the reporting and accounting requirement. So, apart from this particular aspect, I think the other so all these aspects which I talked about with regard to going concern, with regard to impairment of assets and investment, with regard to deferred tax, creation of deferred tax assets, with regard to assets held for sale, because when I look at say IBC, in IBC there can be a whole lot of other issues, because there could be a part of the process, there could be a demerger of certain activities, there could be a demerger of businesses, there could be a discontinuing of operations, etc., etc. So then the accounting implications essentially, I think, becomes more complicated, because then you will have to fulfill the requirements of business combination, and its implication, the court order and NCLT's order and its implications, as we are all aware that as per the Ind AS or accounting standard, the court order actually prevails over the accounting standard. So you can actually give effect to the court order irrespective of the requirements of Ind AS or accounting standard, as the case may be. So that particular aspect will be very critical. When I look at say some of the provisions, and you can actually go through some of the financials which are available on the website, and you will find all these aspects examined in greater detail. There could be post-balance sheet event, depending on where the application for the insolvency resolution is, and the fulfillment of that. You may have to even look at the post-balance sheet event till the adoption of accounts to figure out as to whether those are adjusting events or those are not adjusting events. What happens to the haircut which is taken by the banks and the creditors? So because invariably in IBC or in insolvency situation, there will be definitely a significant haircut, and I think you must have already read that those haircuts sometimes could be 30 to 40% of the total outstanding. What will be the implication of that haircut in the financial statements of the borrower in terms of say write back of these liabilities through P&L account, etc. That particular aspect will absolutely be critical. The other aspect I think which is very important is that as just broadly, that once these proceedings are initiated, the resolution professional actually steps into the shoes of the board. So what happens is that the board actually suspends. The board is suspended. So there will be a situation which is before the board is suspended, and there will be a situation which is after the board is suspended, and the resolution professional has actually taken the responsibility. So what happens is that the resolution professional actually takes the responsibility for the entire company. And they have been given powers to appoint new independent directors, auditors, professionals to help them in compiling the financial information, fulfilling the SEBI requirements, quarterly financial statements, etc., etc. And all those aspects
will have to be taken into consideration. And if you see some of the financial statements, you will find out that because there are certain cases, so there is a cut-off period between before RP was appointed versus before the board was in existence. So many a times, I mean, RP has to essentially, limit its own responsibility vis-a-vis the past transactions, and if you see, I think number of cases, I think, you will find the notes to accounts or a submission to stock exchanges or ROC as the case may be, about what the resolution professionals submissions are with regard to the fulfillment of his responsibility post his appointment versus what happens pre-appointment, and then all complications typically arise in this particular situation. As an auditor, once RP is appointed, whatever financial statements which are issued after that are addressed to the resolution profession, because he steps into the shoes of the board of directors and takes the full responsibility. And then I think, as I said, that depending on the the implications on where you are, typically all these cases will be such that they would have a going concern issue. So the going concern issue, the revival plan, how that revival plan is being fulfilled, etc., etc. And all our auditors' responsibility with regard to our reporting requirements, with regard to qualifications, matter of emphasis, material uncertainty around going concern, etc., will essentially be driven by that aspect. So I have this much to submit. If you have any question, we'll be happy to discuss. I know it's a very technical kind of a subject, and but I think if you have any questions, I think I'll be happy to take to the extent I'm aware of this.
What happens to the status of members in this type of company?
So status of members also gets suspended. Okay, so what happens is that if you see the cases which are which are settled, NCLT actually gives an order that the status of members, creditors, company directors is being revived as if this particular situation has not happened.
When company is applied for stock-off, it has got some assets, maybe encashable assets.
Yes.
And the only liability is the share capital. There is no other liability. It applies for striking off.
Yeah.
Strike-off order is made. Then what happens to that asset? What can be done with that asset?
Yeah, so those
It can be
assets.
freezed or it can be encashed and paid for the share capital.
Yeah, so the only thing is there will be that suppose let's say that you have struck it off and there is no chance of revival. Okay, you are saying that, but that strike off itself will happen only if ROC takes into consideration all these aspects.
So there is no other liability except the share capital.
Yeah.
And some encashable assets.
No, so then the question will be that so even if you were to do a strike off, for example, then the best way for the company will be to actually go for voluntary winding. So because
strike off is not useful in that case.
no, so so suppose let's say take a situation that you have assets, there is only share capital, okay, and you have not fulfilled the statutory requirements, okay, then the company will be struck off. But what we have got is only cash balance and the share capital. Then in that case, what the company has to do is that they have to still make an application to NCLT, saying that we want to revive it for what? We want to revive it to essentially settle this matter and then go for voluntary winding.
There is a difference between putting the active company in the dormant company by the company itself.
In
No
active
real effect except that maybe one or two small provisions may not be applicable.
One is that, and then you are not essentially struck off.
No, not struck off.
Yeah.
I mean, this is another question
Yeah.
where company by itself applies for changing the status from active to dormant company. There's no real significance impact for the company as such,
Yeah.
except maybe one or two small provisions like rotation of auditors or cash flow statements are not required to be prepared.
That's
But
right.
every other compliance is required to be done.
Yeah, so I think typically then you are right that then you rather keep it active.
Active.
And make sure that you fulfill all
Almost
the...
is like, I mean, puts it into dormant situation, we'll just leave
That's a
it.
separate issue. I mean, if ROC on its own does it, then that's a separate issue.
Yeah.
Obviously, it cannot be done without giving a notice. And suppose if some ROC were to give a notice, then what will happen is that if a company were to say that, but we have fulfilled all the requirements of the Company Act, then obviously that strikeout will not be...
The strike-off will not come.
Yeah.
Even ROC can suo moto put into dormant situation.
That's right, yeah.
Only that they can do that.
They can do that.
themselves. Where to live with that? Otherwise, we can.
Yeah, but you can actually apply saying that we wish to keep it live, for example. We don't want to keep it inactive, we want to keep it
He
live.
has got the powers to put it into dormant situation.
Yes.
The company does not start the business within 1 year.
And then the company has got an application, I mean, you can make an application to bring it back because the time limit,
Okay.
outer limit is only 5 years. And then I can continue to fulfill my responsibility under the Company Act and it's fine.
I have an accounting query.
Yes.
To haircut which happens.
Sure.
Suppose there's a haircut of a loan where the loan outstanding was
Just one.
where the haircut happens and suppose the outstanding of the loan amount was some 4,000 crore and the haircut is like 50%, it comes down to 20,000 crore. Whereas 20,000 crore will be treated as an other income or like what?
The 20,000 crores is the right back, you are saying?
Yeah, correct.
No, yes, 20 was liability and 4,000 crores is...
40,000 crore was outstanding amount.
Achha, 40,000 was.
40,000 crores and there's a 50% haircut which is given to the new investor.
Then it will be, because under Ind AS it will be taken to P&L.
So there's an additional liability which comes under MAT.
Liability, financial liability will be taken to P&L. It is not an equity position issue. Then naturally there will be a tax, there will be a MAT issue. But I'm just looking at this particular aspect that there will be a lot of complications here because if I'm saying against 40, I'm maybe writing off what 30,000 you are saying, right? So if you are writing back 30,000 crores and somebody is taking a haircut, that means I don't have the assets to fulfill that. So either there could be a big impairment of asset, right? So that will be appearing on the expenditure side. There will be ballooning of losses. That's possibly is one aspect. So whether after that write back also MAT will come is something which will be fact specific. Yeah, that is one part of it. Second part of it is that if that loss is coming because of the impairment and all that, now whether that impairment will be allowed for tax purpose also is another issue, which we will have to deal with at that time.
What is the logic for having a 20-year window for an employee to call back? I mean, you have periods of 3 years in other cases and 20 only.
Yeah, so I think it's a bit of overlap actually because that other first provision is actually all people, all persons. And this is only these four categories, the company, creditor, member and workman. I mean, essentially, if you were to ask me that one way of to look at it is that maybe it is a protection of, I mean, by including workman, you actually brought in one more stakeholder there. Okay. So suppose, you know, if the intention was actually fraudulent or intention was not intended to serve all the stakeholders fairly, then the good part here by keeping this kind of a long period is to say that even after say 5 years or 10 years you come across a situation that, you know, maybe something was earned or some wrong was committed, you can still continue to do that. So the limitation period actually they have increased to 20 years. I don't think it is so much from a member perspective, but it is more from a creditor and the employee perspective.
Because the implication then is that the directors, while they officially don't have any capacity, for this period of 20 years can be held responsible.
Yeah, no, and the other issue is that now I also try to look at the case law, but I think this particular question maybe a lawyer can answer better. Is that if a company which is say let's say 15-year case, if I were to revive, what will happen to these 15 years accounts? Because I may not even keep those accounts. You know, because those balances, I mean the ledgers and all that will not be with me because there is a period of limitation for that. Very difficult to answer that. But yeah, I mean, theoretically it's definitely possible. So I'm sure in those particular circumstances, NCLT will take that cognizance, right? Saying that if this is the situation, there is this impracticality. And how do you kind of correct that impracticality itself will be one of the key items of the passing of order or not passing the order, or rather to say that okay, no, the company let it be dead, you know, it's possible, or they might even direct the company to go for winding up. You know, because winding up exists, I mean that strike off is only administrative. So court NCLT may say, come to a judgment saying that no, in this case it is better that it is wound up, and then you will go into another process for winding up. Then struck off position will remain suspended.
What is the position in respect of other laws? For example, going back to the same hypothetical situation of a company getting revived, say after 10 years, you can't even file income tax returns beyond 2 years.
Yes.
So, and there is no equivalent provision under the Income Tax Act which allows you to file retrospectively.
Yeah.
So there seems to be a huge gap between the provisions under the Companies Act vis-a-vis your obligations under other acts.
Yeah. So the only thing which I am just envisaging is that let's say that situation took 10 years, but people were carrying on business. I mean, you know, the business was being carried on. So then I think what is the provision under the Companies Act? My income tax requirements will have to be fulfilled separately. You know, so those with regard to preparing financial statements for the purpose of filing return, etc. If the company has been doing it regularly, maybe that particular part is taken care of. But if the company was carrying on business, not doing income tax filing, not doing Companies Act filing, then the implications will be significant.
I'm looking at a scenario where the company's name is struck off.
Yeah.
So officially the directors have no responsibility to file returns.
Yes.
Then 10 years later the name is restored.
Yeah.
Obviously you can't go under the Income Tax Act and ask for a revival of the PAN.
Yeah, so but I think what will happen is in this particular situation is that let's take a situation that why somebody, so the only strike off where such a situation will arise will be the fulfillment or non-fulfillment of statutory obligation, which is not filing annual returns or not filing the financial statement. So I was continuing to carry my business, I was also preparing accounts, I was also getting it audited, I was just not filing it. Okay. Now in that particular situation, I have taken care of income tax return and all that. But the company struck off. I am continuing to do all these activities. So then when I realized that the company has been unjustly struck off, now in this particular situation where I am actually a profitable company and all that, I will not let the strike off continue. You know, then in that case, I will actually go to the ROC because at some point I will not be operating the bank account. Okay, and where do I pay my creditors and all that? So it will start giving, it will start affecting the business of the company. Maybe 1 year you could survive because of certain things, but beyond that I don't think, because your all bank accounts will be frozen. Maybe if your loans, all those will be essentially frozen because the banks will be given notice to. Now obviously once the banks get the notice for freezing of account, then the first, I'm assuming that the first people to wake up will be the banks saying that how this company has been struck off. So they will be the first to say that okay, now let this company be revived, and then maybe they will start making the application first. That's how I thought will be. So, I mean, very unlikely that but in this 4 lakh company situation, there could be such situations, and I think we have also seen that there were a number of newspaper reports where people said that no, we are unjustly removed, right? Because we are carrying on the business just because we have not filed the return. But barring that, I would say that majority of the companies would be like a shell or like somebody who just got a share capital and bank balances or nothing at all, and they're just dormant and doing nothing. It will be majority of the companies. Okay, thank you very much. Thank you for your patience. Thank you very much.
Thank you, sir. It was an interesting presentation on along with the relevant case studies. And now I request CA Antra sir to come forward and give a memento on behalf of Bangalore branch and the audience. Please give a round of applause for the speaker, today's speaker. Thank you, Antra sir. Along with this, there are two more announcements to be made, which is one is happening Mantana program on 26th of April, which is on the audit quality issues and reporting and its indicators. Please do get registered for that. And one more residential seminar is happening at Golden Palms Hotel and Spa on Tumkur Road, off Tumkur Road. The details for the same is available on the website. Kindly to get registered. Thanks a lot for the audience for being so interactive and participative. Thank you, and we are concluding today's session.